Podcast is now starting. All attendees are in listen-only mode.
Morning, everyone. This is Patrick Kim, and I'm the work comp specialist at Beere&Purves. So I just want to thank you again for joining on today's webinar. So if any of you have been following this series, we went from the basics of work comp coverage to how to read quotes, and now we're on the basics of workers' compensation claims. Claims can be a sensitive topic for the insured, and this is because they have an injured staff member that needs to get service as quickly as possible, and the work comp claims process is actually quite heavily regulated. In order to navigate the claims process and make sure that injured members can get back to work and lead normal lives again, we have to make sure that all the I's are dotted and T's are crossed as we help the insured navigate the claims process. So, as always, everything we go over today is general information for California. So for today's agenda, we'll be going over what kind of claims are covered by work comp, what to do when there's a claim, what paperwork is needed, how the claim is processed, why might claims be denied, and some compliance items we should be aware of when we're trying to navigate a claim. Oh, and the webinar is being recorded, so if you do miss anything or miss something in terms of taking notes, don't worry, the webinar is being recorded, and at the conclusion of this webinar, we'll be sending you links to access it again. So for workers' compensation, it covers quite a few natures of the claim. What's going on here? Bear with me, I think we're stuck in a little technical. That was odd. Okay. So in terms of what kind of claims are covered by workers' compensation, the claims are actually quite diverse. Generally speaking, the rule of thumb is if an injury occurred on the job or because of the job, work comp is going to cover the injury. So a common example would be an employee that slips and falls and can't go to work, and the employer can't do a temporary replacement assignment, like let's say they're a contractor and the employer doesn't have an available desk job. The way kind of the workers, assuming kind of the way the work comp claim process is going to work is in terms of like what kind of claims are covered is the injured employee would go see a doctor, the doctor would prescribe pain medication, and the member would undergo therapy. So while the employee is getting physical therapy, part of their wages is being replaced by the work comp carrier. So in that full example where the injured employee slips and falls, has to see a doctor, get pain meds, and go physical therapy, and get some wage replacement, we went from the very basics of just typical medical coverage all the way to temporary disability. So that kind of encompasses what kind of claims are covered by workers' compensation. Even sometimes, an example would be dental care. These are few and far between just because of the nature of that kind of claim. Something related to maybe some sort of reconstructive surgery or anything like that because of someone lost a tooth or whatever, or broke their jaw and they lost some teeth. That would be covered by workers' compensation as well. Not going to go into too much detail of that because those are kind of tricky in terms of processing and working through. Another considerations you see here is supplemental job displacement benefits. That is something that's no longer relevant in the modern era. This was something that was used, I believe, in 2000 up to 2004. The idea here was that if an employee could not work at their old job and an accommodation couldn't be made for them whatsoever, the supplemental job displacement benefit would essentially be the injured member would get a voucher to go to an adult school or trade school to learn new skills so that they can get a new job. This is no longer relevant in the modern era, but just something to be aware of. Largely, this really only occurs in grandfathered situations. And of course, for workers' compensation, death benefits are also covered as well. The death benefit component of workers' compensation really is intended to cover burial expenses and provide financial support depending on whether or not the deceased has dependents. The details of how those benefits are paid out, including some of the details regarding disability coverages, are very, very detailed and actually follow kind of a strict schedule, so that if that'll probably be a completely different conversation for later. If you have any specific questions regarding those, just let me know at the conclusion of this webinar, and we can work out that way. So really what to do in the event there's work comp claim, obviously depending on the nature of the injury, you should just call 911 first. I've had insured call me directly to report the claim instead of calling 911. If it's a medical emergency, just call 911 first, and then we'll hash out the details of getting the claim and all that squared away after the 911 call. But essentially just get the employee to a hospital and worry about the paperwork afterwards if it's a medical emergency. Otherwise, we need to try to get the claim reported. Usually a work comp carrier is going to have some sort of nurse's hotline or phone service or online work comp claim reporting system that either the injured employee can use or HR can use to report the claim and get that member service. And when I say service, I'm referring to having the employee get actual medical advice from a trained nurse and getting a medical appointment set up for the employee. But despite that, we still need to make sure that all the I's are dotted and T's are crossed and we submit correct paperwork at all times. Again, workers' compensation is quite heavily regulated, so that's why we always have, even if there's a 911 call, we do have to eventually make sure that the member is getting paperwork. So in terms of documents, for California, the work comp claim form is called the DWC-1 form. This is a statewide form, so any reference to a work comp claim form is going to be referring to the DWC-1. Essentially, the form has two sections, one for the employer to fill out and one for the employee to fill out. And I always recommend that both the employee and employer keep a copy of the completed document. This document needs to be submitted to the carrier whenever there's a workers' compensation claim. In the event that an employee cannot work and a replacement assignment can't be found or accommodated, then a wage replacement or a wage statement form needs to be completed. The carriers might have their own form with their logo on it, but generally speaking, the information is going to ask similar things like what is the employee's wages, how much does it work, et cetera, et cetera. The accident report form isn't something I find used now, since the DWC-1 form is so vital and pretty much asks for the same information that's going to be on the accident report form. And even then, any additional details regarding the claim can be reported via online or via phone, either directly to the adjuster or to a general inbox in terms of whatever details are needed. I actually have a copy of those, so if you just bear with me one moment. So this essentially is the legal fluff. With me, there's a lot of it. And this is essentially this is the vital component of the DWC-1 form. So as you can see, employee section, a lot is very basic information, name, address, date of injury, time of injury, where it happened, nature of the injury, et cetera, et cetera. The employer section also is very basic information as well. So, and again, we just want to make sure that you're always keeping a copy, a completed copy for the employee and one copy for the injured employee at all times. Absolutely vital. So this is the California wage statement form. This is a copy from employees' compensation, but generally speaking, from carrier to carrier, it's going to ask for essentially basic information. When the claim is filed, there's going to always be a claim number, who got injured, nature, date of injury, et cetera, et cetera. And again, just pretty darn basic info. It shouldn't be intimidating at all in the event this happens. And again, another claims report form asks for effectively the basic information as well. This is more for, okay, the claim occurred, why did it occur, and what can we do to prevent it in the future. Again, I rarely see this being used at all, typically because the DWC-1 form has all the information and the claims adjuster is going to work with the insured directly in order to figure out, okay, what mistakes were made, how can we avoid them in the future. So how a claim is processed, this is about this is about as generic and simple as it gets. Again, the claims process is very simple. To kind of go through it, an employee gets injured and they're handed a claim form to complete. Again, this is assuming it's not like a 911 emergency. The claim form gets completed, and by the employee and the employer, they both get a copy. Completed form gets sent to the carrier, and the employee sets up a medical appointment through the work comp carrier. And while the member is getting service, they can seek up to $10,000 in medical services while the carrier processes or investigates the work comp claim. And assuming the claim gets accepted, the carrier finds if it's a true work comp claim, it's not fraud or anything like that, the carrier will disperse benefits above that $10,000 limit. Something to note is that if the member just goes to any hospital and says, hey, I got injured on the job, I need medical services, the member needs to provide the carrier's name and policy number. I find that this is something that typically gets missed. That's not something your average employee is going to know on the back of their hand. Usually what happens is the employee goes to the hospital expecting medical services, and then they say, oh, I got injured on the job. The hospital says, okay, that's fine. What's your carrier name? What's your policy number? They don't know, so typically the injured employee is going to just give off the name and contact information of the HR person, and then the HR person might get a bill, or worst case scenario, the employee gets a bill. In both situations, the employee and the employer are not supposed to receive a work comp bill. Work comp bills are supposed to go to the carrier directly for all services. So in the event that there is an injury, it's probably recommended to write down the carrier name and policy number just to give it to the employee as they go to the hospital. Or ideally, they're using carrier resources in order to make that appointment. Again, that's because one, the member is going to typically is going to talk to a trained nurse that's going to give them consultation services and triage them. If they can avoid going to an expensive hospital visit, that's ideal for everyone. And two, if it's just something minor and the injured employee just needs some calming down, needs some help navigating the injury, you want a nurse to do that. So that's why they're there. And also, again, they can set up those medical appointments as well. So if the nurse says, oh, I think you have a serious sprain, you need to see a chiropractor or something like that, the nurse typically can set up that appointment on behalf of the member and reconcile information that way. So before I get into this slide, there's actually something I do have. This is essentially kind of the workflow of what I just shared. The one thing that kind of deviates from the workflow I shared is this, where if an employer, and this does relate to kind of the next slide, which is compliance, is that if an employer does not hand a claim form, the DWC-1 form, to the injured employee, the employee can in fact reach out to, I believe, the Department of Industrial Relations Information and Assistance Officer via phone, or just hop into their office and file a complaint. And then there's going to be more compliance action, which can get pretty darn messy. But let's assume that everything went accordingly. The employer provided the employee the claim form. Everyone completes a copy. Employee keeps a copy. Employer keeps a copy, and a completed copy is sent to the carrier. The injured employee again can get that $10,000 in medical services. If an employee is not authorized to get that $10,000 in medical services, they can again seek compliance action as well. And this is just a situation where the carrier is going to say, okay, your claim is bona fide, we're going to process your claim. But generally speaking, claims are denied when the claim is determined not to be work-related. These are situations, so one example would be, let's say there's an employee, they work at a law firm, and they're having a lot of stress. They have a mental breakdown, let's say, and they go seek work comp services. Work comp does in fact cover some therapy appointments, and the therapist determines that, oh, your mental breakdown was not work-induced stress, then no benefits beyond the initial 10,000 services will be offered. the $10,000 services can still be provided, so the member can still go and see mental health that costs up to $10,000. But anything in excess of that, the carrier is going to say no if the treating physician or practitioner determines that the claim, the injury, the illness, whatever, is not work-related. And obviously, if a claim is determined to be fraudulent, it's going to be denied. Claim benefits can be delayed, keyword delayed, if the claim is being investigated for fraud. Obviously, if a claim is not filed timely, a claim can be denied. I've never experienced something like this to ever happen. Typically, carriers are pretty timely about responding to a claim, and members are also pretty darn timely when it comes to filing claims on time. The last one kind of relates to my previous point where the claim is filed well after leaving the organization. This is because the carrier might say, well, that's the responsibility of your new carrier now, or it'll be a situation of the lawyers get involved and they have to hash out who's responsible for the claim. But typically where it starts is the claim doesn't get paid, and then the lawyers hash it out. So compliance issues regarding workers' compensation. Work comp is supposed to be the exclusive remedy to work-related injuries or illnesses. Insured should never be paying for medical services of injured staff or injured employees. Employees cannot be terminated or be retaliated against for filing a work comp claim. Fraudulent claims obviously can be punished with fines or jail time, and if group does not have workers' compensation when a claim occurs, the employer can be held financially responsible for all the medical bills, and will probably have to appear before the labor board or some other regulatory entity to explain why they didn't have workers' compensation. And that's not even touching on to all the legal fees and such that can also happen when an employee does it. Well, usually file a civil lawsuit against their former employer. So this is really about it. Now is the time for Q&A. As previously mentioned, everything is recorded. So if you have any questions or concerns that you can't think of now, or you would want me to interact with you directly, that's perfectly fine. But at this time, I'm more than willing to take any questions or concerns you might have right now. So again, when considering workers' compensation claims, just be aware that we do have to make sure our I's are dotted and T's are crossed. If there's something you're not sure about, always make sure that your members are getting that DWC-1 workers' compensation claim form. Make sure it's completed and make sure that's always submitted to the carrier. And if a member goes out and seeks medical service independently, always make sure that they're providing that carrier name, employers, travelers, State Fund, State Farm, whoever, and make sure they're providing that policy number. Because unfortunately what can happen is that the hospitals just kind of say, well, we reached out to the HR person, we don't know who's supposed to pay us, so they'll kind of just start flinging bills. Not exactly randomly, but they start flinging bills to people that shouldn't be getting the bill. First and foremost is that the member typically gets the bill, which they're obviously not supposed to, and then that can cause quite a bit of ruckus because essentially the way it works is the hospital's billing the employee as if they had no insurance, when the reality is that, no, it's a work comp claim, the carrier's supposed to pay for it, and they're supposed to hash it out. All the members should be focusing on is healing and getting better. So I know this was kind of a faster webinar. Again, some of the details regarding the work comp claims process is extremely detailed, so I kind of want to hit on more of the broad points. But if you have any specific questions, please let me know. My contact information will be sent out to you in order to ask any questions you might have. And as previously mentioned, this webinar is recorded, so we'll be sending you out a link to the recorded session momentarily, as well as with any materials you might have. Again, thank you all so much for your time. I really appreciate it, and enjoy the rest of your day. Thank you.